from state to state. The concept is consistent throughout the country. And therefore, I think it's fair to say that there is a national consensus that there is such a distinction, it's a valid distinction, and it is one that court staff, whether they're law trained or not, can use. And the challenge for a speaker on the topic is to make clear what that distinction is and help you, give you the principles and images that you need to apply it appropriately. California, you in California are blessed because many of the minor sub-issues in this topic that cause fretting in other states have been decided in California, and you have answers to the questions. And the answers come from these source documents. By the way, I am going to provide this PowerPoint presentation to Joseph Wen, and he'll put it up on the website so that you can have access to it. You don't have to aggravate your carpal tunnel by trying to take too many notes. You should, though, have the handouts, which are 2 of these 5 documents. This one, the May I Help You form or publication, and the guidelines. But understand that there are some other legal documents. This one is actually included in the May I Help You handout, but you may want to look yourself at, well, heck, those of you who are facilitators are certainly familiar with Facilitator Act. And the Rule 10-960 is the basis for the guidelines. What I'm going to do today is go through first an intellectual, theoretical model of the distinction and how it is derived from, but different from, traditional unauthorized practice of law analysis. And then take you through your own guidelines and standards and ethical rules in California. And then, and this was the major purpose of the session today, talk about the tough ones, the hard issues, the areas that make you clench your gut, and where you're just not sure where you're going. So if, as we're going along, you can make notes to yourself about those issues that you find most perplexing and give you the most discomfort, that would be helpful. I have a few that I'm prepared to discuss, but I want to make sure that we address the ones that are most perplexing for you. So when we get to that point, I will ask for your input. The distinction between what clerks can do and what court staff, we're including now counter staff, self-help staff, facilitator staff, small claims advisors, legal aid lawyers working in a courthouse, legal aid workers not working in a courthouse, law librarians, public librarians, all of those people are affected by this topic. But the legal structure for thinking about it and the basis for those old signs, I hope none of which continue to exist in California. Clerks cannot give legal advice. Don't ask. Was the unauthorized practice of law analysis. Persons who are not lawyers cannot practice law cannot do lawyer things. And if they do, they, in some places, are committing a crime, but they certainly can be punished in different ways for violating the law, because they are doing something that the law prohibits them from doing. So that's why those signs were up there, because court clerks working in a court certainly don't want to be violating the law. But the UPL, unauthorized practice of law, is UPL, analysis was dichotomous. There are lawyers, and lawyers can do lawyer things. And anyone else cannot. And so persons who are admitted to the practice of law and in active status can perform like lawyers within their area of competence and subject to the limitations of the lawyer-client relationship, including most particularly conflict of interest and duty of loyalty to the client, so that you cannot provide assistance to someone on the other side of the case, or you cannot provide assistance to anyone whose interests are adverse to your current or former client. A committee of the Washington State Bar reanalyzed for the Washington State Supreme Court a few years ago the topic of the unauthorized practice of law. And they came up with a, what is the opposite, what is it? A trichotomous? A trichotomous analysis. They said, yes, there are lawyers over here, and there are non-lawyers. But then court staff, people working in the legal system, should be analyzed differently. And if they are doing what the court directs them to do within the framework of limitations established by the court, they are not engaged in the unauthorized practice of law, even though what they are doing would be considered the unauthorized practice of law if it were done by a strict lay person, or a real estate agent, or a notary public. And why is this? Well, and this is the analysis from Washington State. Persons working in the court, even though they may not have a law license, have a great deal of knowledge about the law. And so the risk of their giving information to the public is great. The risk of harm to the public from their sharing that information is much less than the risk of somebody who works collecting garbage giving the same sort of information. And they said the system can't work, the court system cannot work, if there are not people in the court who are able to give this information to litigants and potential litigants. We cannot have access to the legal process if there is not an opportunity for people who cannot afford lawyers or choose not to have lawyers to get the information they need to use the system. So we have to have this category, and having this category does not subject the public to any significant risk, so long as the people functioning in this middle area are working within guidelines established by the court. This Washington State analysis, I think, is spot on. I also, though, think that it probably doesn't go far enough because it does not apply to, for instance, law librarians or public librarians who are in much the same status. So, but of course that wasn't their job to look at that category. So I would think, in my own analysis, I would add some more people to that middle category. But this is the theoretical structure of why the traditional unauthorized practice of the law analysis doesn't apply in a direct way to what non-lawyer court staff can do. The other side of the coin, though, is that lawyer court staff cannot do all of the things that a private lawyer can do, or a lawyer in private practice can do, because lawyers in the court structure are constrained by the imperative that the court be strictly impartial. So this middle category of persons are able to do a lot more if they are non-lawyers, but less if they are lawyers than the categories on the left and the right. We'll lay that out. So the principles, this distinction between legal information and legal advice applies to all court staff, whether they're lawyers or not. It applies to any other person in the courthouse providing self-help services, whether or not they are employees, direct employees of the court. For instance, in Los Angeles County, the Neighborhood Legal Services provides the self-help centers in a number of the courthouses. Kathleen, what is it, 13 or so?
9 of the 13.
So those legal aid lawyers providing self-help services in the courthouses in Los Angeles are treated exactly the same way in this analysis as court-employed attorneys in Los Angeles County or in other counties. Legal services throughout the country have also been using the same distinction for their own service provision in their own offices, so that they have established a category called assisted self-help, where they are providing information rather than advice to persons to enable them to assist themselves in court. And they use the same analysis that when they are giving only information, they are not establishing a lawyer-client relationship, and they then have no duty to avoid conflicts of interest arising from that assistance. And then law libraries and other libraries are using the same distinction so that they are comfortable giving a lot of information, but protected from having established inadvertently a lawyer-client relationship between themselves and a library patron. What court staff can do, then, is determined not by principles of unauthorized practice of law, but rather by the ethical obligations of court staff that derive from working in a court. And those are to remain impartial. That's the primary imperative. with respect to parties in the case and with respect to lawyers in the community. And that's why a court staff member can never recommend a specific lawyer. If you recommend a lawyer, in a way, you are ending up showing partiality toward the clients of that lawyer when that lawyer appears in court. You have to maintain confidential information, avoid ex parte communications, and this topic is discussed at some length in your guidelines. And you have the overall imperative to perform competently, just like a lawyer has that ethical obligation. And that translates into don't guess, never guess about the information you're giving out. If you're not sure about what it is to say nothing. A medical principle is primum non nocere. First off, do no harm. So when you apply those ethical principles to what we in the court do in interacting with people coming to us seeking help, we use these definitions for distinguishing what we can and cannot do. Legal information is facts about the law and the legal process. And legal advice is advice about the course of action a client should take to further his or her own best interests. And you think about it, that's what the lawyer is really doing. This is what you should do. I'm telling you what you need to do. And that is what we do not do in the court. And the reason we do not do that is because that is taking on a role that is antithetical to impartiality. Actively pursuing the best interest of a litigant means minimizing or undercutting the interest of the other side. So a way to think about this is to, every time you are interacting, assume that both parties are in front of you and you are providing information equally to both of them, because that is the posture you're always in because you work in a court. It's not just the judges who have the duty of impartiality. That impartiality duty goes down through the entire court operation. And if you think about it, that's the only way the court can be fair. A handy way of thinking about this is that questions about who, what, when, where, and how are eliciting information, where questions about what should I do, can you tell me whether to do this or that, are seeking direction, advice, what it would be in my best interest to do. These are not good, complete litmus tests, and the most obvious dodge, because people are going to try to get you to tell them what to do. That's what they want. And the easiest one is, well, what do other people in my situation do? That's a what question. But it's actually a should question masquerading as a what question. And we're smart enough to see through that. So we do tell litigants how to bring an issue to the attention of the court. But we don't tell them whether that's wise for them to do it. We don't tell them how best to present it. And we don't guess how the judge is likely to decide it. even though we know this judge very well, and the judge has had this issue before her 1,000 times and has never differed or deviated from the decision pattern once in those 1,000 times. We still never predict what the court is going to do. We inform a litigant about his or her options and the steps needed to carry out those options, but we do not say which option is in the best interest of the litigant. Legal information is educating the litigant or potential litigant, giving the litigant the information the litigant needs to decide for him or herself what to do. Legal advice is guiding or directing the litigant or potential litigant. So a way to see this is, as a lawyer, when a client comes to me, I am constantly thinking, what should this person do? And that is then, my role is to tell the person what to do. Of course, it is always up to the litigant, to my client, to make the final decision. But my role is, and it's all associated with my duty of loyalty and zealous representation and all this, to further my client's best interest. But as a staff person, that's not the question I ask. I don't ask, what should this person do? I ask, what information does this person need to decide what to do? And in a way, that is a harder task than just saying what to do. It's one step further complicated. But I think this is an essentially important notion. Just keep that in your mind, that the question I'm asking myself in interacting with this litigant is, what information does the litigant need to make up or to decide for him or herself what to do? It's always appropriate for court staff, lawyers, non-lawyers, to provide information that's set forth on a website or that could be included in a website or a law book about a generalized statement of the law or procedure or practice. So go back to your teacher metaphor. It's always appropriate to teach from the textbook and say what the law and the rules are. And I think what I hope we will demonstrate by the end of the session is that how the communication is framed determines whether you're performing appropriately or inappropriately. I have not yet come across a situation where a court staff person or lawyer in the court cannot provide what the litigant needs as information if you think it through and approach it from a neutral standpoint. You're never in the ultimate bind that I have to let this person drive it into the ditch without any understanding of where the side of the road is. Now, in a way, what I'm telling you is it's all a matter of semantics. But that is what I'm telling you. And in the law, semantics are incredibly important. So this This is a summary of the rules for you in California, derived from, mostly from these handouts. You can, and where you see can, you really need to say should, because you're in the business of providing information. You should explain court rules and procedures, but you don't tell a litigant which of available procedures the litigant should follow. You provide information from the file about what's happened in the past. You don't predict what the court will do in the future. You specifically are authorized to explain court rulings and orders. That's a place where you're ahead of the game. In other states, that would be a burning issue. You can provide citations to or copies of statutes, rules, ordinances. You cannot provide an analysis of those statutes or ordinances as they apply specifically to the litigant's case. You can provide general referrals to other offices and persons, but not to a specific attorney. You can provide forms and instructions and record on the forms information provided to you by the litigants. Believe it or not, in a number of states, whether you can provide forms is a big issue. And in Maricopa County, which had the first self-help center in the country, they still tell staff that they cannot pick out the form for the litigant. So when you go into the Maricopa Self-Help Center, you see a wall just lined with different sets of forms. And on the front of each one is a list of the circumstances or factors that would make this the appropriate form. But the litigant has to go and read all of these different forms and then decide, okay, this is the one that's right for my case, take it over to the staff person who will then sell them that form. You are under no such constraint in California. It is entirely appropriate for you to elicit the information that will tell you what the appropriate form is. You can also check a proposed filing for completeness, inform the person of specific problems in the filing, and how to fix them. But you cannot draft the wording to be entered in the fix. It has to be, you can put down the litigant's words. You can put them in correct English, but it's the litigant's words and not your words. Where when you're practicing lawyer, it's the lawyer's words, because the lawyer is purposely using legally loaded language. In California, you specifically are authorized to help litigants figure out when something has to be filed. What is 10 days after mailing of the document to which you're responding? What is 30 days from the date of service? You are allowed to use the rules in the principles in the rules of procedure to figure out what is 10 days. The May I Help You document, which is intended for court staff, says that you are not to speculate how the statutes of limitation would apply to a litigant situation, that that's too complicated. That was drafted for counterstaff. I don't think that that absolute rule should appropriately be applied to self-help center staff with law training. On the other hand, when you are providing information about statutes of limitation, you've got to always caveat whatever you say, because you're never going to be doing sufficient analysis to be 100% certain how the statutes would apply. For instance, whether a matter arising out of a breach of some sort of agreement is really a contract matter or potentially a fraud matter, which would have a different statute of limitations. And in the earlier session, there was a good deal of banter between the self-help staff and the librarians, because the self-help staff would say that they would tell litigants, these are the statutes of limitation and these are the periods. But if you want the law library to tell you more about how you define a contract or a personal injury tort or property damage tort, how those would work. And the librarians say people hear that as the librarians will tell you what statute of limitations apply, rather than guide you to source materials. This is one of those issues which in 99% of the cases is open and shut, and the other 1% is murky as hell. So back to our analogy about the teacher rather than the counselor, what you're doing on statutes of limitation is saying the statute of limitations for contract action is years. And the statute of limitation, the purpose of a statute of limitation is to require a person to file a case within a certain period of time, and if you don't within that time, then you lose the right to get damages for what happened in the past. Then the other issue that of course can come up here is not just characterization, but tolling. So full information is that there are some situations in which that time limit could be extended based on the underlying facts, but we can't go into that here. You can, this is explicit in your guidelines, provide standardized boilerplate, fillable, and I took those words word for word from the guidelines, points and authorities that can be used by self-represented litigants. And you can develop forms for use by self-represented litigants, but you cannot tailor a individualized points and authorities document for a specific litigant. I think I've been told that that derives from the early days of the facilitator program, where some facilitators actually took on a role of being counsel against child support for persons having conflicts with child support, and would support them in all aspects of their attempts to resist what Department of Child Support was seeking, including drafting elaborate pleadings and points and authorities. As a court staff person, you cannot choose between Department of Child Support Services and the non-custodial parent. If there's a conflict, you're providing information you would provide to DCSS if they ever came to see you. Same information to both. You are specifically authorized to explain and clarify court orders. You're specifically authorized to assess the status of a litigant's case and provide directions concerning court requirements and procedural next steps. I'm aware of a state which specifically prohibits staff from telling anyone what the next step is. this is an interesting extract from the guidelines that I just decided to quote to you verbatim, because it's the kind of thing that is very, very helpful to you. So it starts out, you're not only impartial, but maintain the appearance of impartial. Services are standardized so that the same persons asking the same question get the same answer, regardless of who the staff person is. However, you can tell a litigant that a declaration needs to be completed and may provide guidance on what kinds of facts a court would need in order to decide the issues. Staff may ask appropriate questions to assist in clarifying the facts and otherwise promote a focus on facts relevant to the court. But the declaration is in the litigant's own words. So the facile notion that the application of the law, of the facts to the law to the facts, as practice of law, and therefore inappropriate, is completely undermined by that. That's what you're doing. You are paying attention to the facts, and you are looking at the facts with your overall understanding of the law. And you are guiding the litigant to understand what are the relevant facts, so that you are making sure that the relevant facts are there. This is a very tricky situation, but the bright lines that would make it really difficult for you to operate in this situation don't exist. You are allowed to ask questions, elicit information that then allow you to provide the appropriate information. You must provide the same assistance at the same level of service to both sides of all types of cases served. And the two issues that have come up are UD and DB, where it's easy to, maybe not in these budget times, but in flush budget times, to get advocacy groups to come into the courthouse to provide services for tenants and battered women. But nobody is coming in to provide assistance for landlords and abusers. But the principle of your guidelines is, if you're going to provide those services in the courthouse for one side, you have to find a way to provide comparable services to the other side of the case. And that doesn't mean it's not enough if the battered woman is getting an hour of help one-on-one from the advocate. It doesn't do just to give the respondent one piece of paper and say, this is what you have to do to respond. It has to be comparable in depth as well as existing in fact. At the end of those guidelines, there is a list of what are said to be ethical guidelines. So I just want to review those with you. You must uphold the independence and integrity of the self-help center or office. No definition is given of independence or integrity. All persons working in a court-based self-help center must recognize that they are and will be perceived by the public as representatives of the court, and must at all times avoid engaging in conduct that creates an appearance of impropriety. And I think that that is intended to focus on impartiality. All attorneys and staff must perform their duties impartially and diligently, and you are given definitions of those. Impartially means delivering services in a neutral manner. Diligence means providing litigants with pertinent information to allow them to bring their matter before the court. So your ethical duty of diligence requires that you find a way to provide the information the litigant needs. And so if you don't know the answer, you certainly can't give it, but you have an obligation to either go find it out and ask him to come back, or refer him to somebody who could give it to him. All attorneys and staff must be aware of the social and economic differences that exist and treat users with patience and respect. However, you can toss out litigants who are not treating you with patience and respect. You must not exhibit bias or prejudice on any basis, and you must require all staff to behave this way. You must provide competent legal information. You must post conspicuous notice. And the first one of these notices is not included in this ethical section, but it's in another section of the guidelines, requiring you to do the same thing. So some of you may not have on your notices this specific statement that services are not intended to give one side of a case an advantage over the other. So going home, you might look at that. Your signs probably do say that no attorney-client relationship exists, that communications are not privileged, and that information may be provided to the other party. You may not make any public comments about litigants or about any pending or impending matter in the court. I found that interesting, that you cannot make any public comment about the litigant. It's not privileged information, but there's a separate ethical standard that says you will not make public comment about it. So if you're required by a judge or in a sort of deposition setting to give information, you must, because it's not privileged, but you otherwise don't make public comment about the litigant. You may not accept anything of value from someone you assist. I think a kiss or a handshake is not of value. You must avoid all ex-parte communications with bench officers unless working as a research attorney or in a capacity permitted by Family Code 10,005. Now, one of the sections of that, this is the part that says court by local rules can assign additional duties to the facilitator, including preparation of orders after hearing. So I think this is addressing that, so that you certainly are allowed to talk with a judge when you're trying to understand the order, the minute order, and draft an appropriate order after hearing. Carl, does that make sense? But you are specifically prohibited from offering, I fixed that, I don't know why it came back, an opinion to a bench officer on how the bench officer should rule on a pending case. But you are encouraged to talk generally with bench officers about procedural matters and the functioning of the court. So long as you take it out of the context of a specific case, you can talk with and are encouraged to talk with the court about the process. You must not provide assistance on any issue on which an attorney actively represents a litigant. assist someone who was ever represented by a lawyer. It says you cannot provide assistance on an issue on which an attorney actively represents a lawyer. Represents a litigant. So the fact that there's an attorney listed in the case does not bar you from providing assistance if the attorney is no longer in the case or the attorney was providing unbundled services limited in some way. And of course, if they have a lawyer, you may advise them how to get rid of the lawyer, and if the lawyer is trying to get rid of them, how to deal with that, or what their options are in dealing with it. And you must see that all volunteer attorneys or other volunteers who are working in the office are following the same guidelines, that they do not solicit or accept clients as a basis of their volunteer service, or hand out their cards, or make referrals to a specific attorney. So, that's the review of the specifics of the guidance that you have gotten in California. Now again, reiterate that you should feel privileged to have the extent of guidance that you have, because it's when these things are left unanswered that court staff or lawyers working in courts are more anxious. So at this point, let us apply these principles to difficult situations. Are there specific problems that upset your stomach that we can talk about? Carl?
Well, one of the issues I have when I go over this is when it starts to worry me more than every day you kind of get caught up in doing it. But let's say you have someone who comes in with a child support case and their claim is, I never knew about this case, or how is it that I owe $50,000 in child support? And we do the same thing where we flip through the file, we tell them everything that's happened procedurally, and we're helping them look for the possibility that service wasn't done properly. They subserve the custodial parent's mother, that's always a favorite. And so then we tell, explain, okay, it's the way to get into court, file out a notice of motion to set aside, but there are a number of, and we have form points and authorities, but there are a number of points and authorities for them to select amongst. Now, we, based on our analysis of those facts and going through that file with them, we don't just hand them 5 points and authorities and say, pick which one. We say, well, based on what we found in your file, this is the one that has to do with, no proper service. But then sometimes I begin to look back at these and I begin to wonder, is that one step too far?
Well, my statement to you would be that in California, since you are specifically authorized to choose the appropriate form, that this is an extension of that same principle. That in California, you are urged to elicit the relevant facts that are pertinent to the provision of information, and eliciting the facts about the issues that the litigant wants to raise in the motion is then giving you the information that you need to say, this is a form set of points and authorities that we have drafted for the situation of a question about the adequacy of service. You should read through it and use it if it's appropriate. This is the information you need to make up your mind. informing the litigant about service issues? Give me your semantics.
That in California, the law of service is that, you just spell it out for them, and you can be served, the following methods. Subservice is appropriate if the following things have been done. We just explain the law of service, and then as we look through the file, if, like I said, it was custodial parent's mom who was served, well, in the old files, the address is there. In a newer file, in a child support case, we're going to have to go get the address. And then we just ask them, what you need to look at is, did you live ever at the address where you were served? If you are going to claim that you didn't live there, the burden is on you, and you need to collect evidence to prove that you did live there. That's how explaining is what they should be gathering to raise a claim of improper service. So we just try to spell out the law of service. But if they come back to us and they say, okay, well, here's my lease from where I really lived, and it clearly wasn't this address at this date, we hand them, our standard, no proper service points and authorities.
I don't see any problem at all with that. Brent?
I'm curious if any other courts have seen this. This is happening in our civil self-help centers where these paralegal services are bringing their clients into us. And I've directed our attorneys in the civil self-help center, you can basically ignore that person. You're there, you help the customer. But it's a really kind of a tricky situation, and sometimes, they're kind of sneaky about it. They don't, obviously they don't come in and say, we're with this paralegal service, but I'm curious how other courts are handling that. As obviously, we're open to serve everyone, but, it's different with we have the general rule on if someone's represented by an attorney, but what courts are doing when basically, these people are getting paid a fee to help someone, but yet they're coming to us to do the work.
Oh, I think they're earning their fee.
That's really good service, right?
That's right. They're getting competent information. How did anybody else react to that? Yes.
Well, they are sneaky, and we have a policy of especially with our spaces so small, we just would let the other people come and we just ask them. So we can't object to the person getting off of the alley, or we can't refuse off because they also have a alley, but we just don't let them come.
Now, would you let a family member?
No, it's just unless it's an interpretive situation.
Did you all hear what Farida said? That because their space is small, they don't let anyone other than the parties themselves come in to participate in the discussion with the self-help staff. So that would apply to the paralegal or any family member, or how about the current girlfriend? Especially the current girlfriend.
John, the other thing is that while we may be required to help everyone, it's also true that you can post written information and you can reiterate to people that the resources are not to be used by anyone for profit-making purposes. And so, for example, a notario cannot come in and use one of our computers to churn out the documents they're going to charge somebody for. And while people are going to be sneaky and slip through the cracks, often you can tell that it's a notarium, that it's not their sister trying to help them, that it's a notarium. And to say very clearly, these resources are available, our help is available to any party for free, but it is against our rules for someone to be charging to help you with anything here. And you can just as subtly make it clear to them that they don't need that person, and they shouldn't be paying this person to bring them back.
Thank you, Kathleen. Yes.
Biggest problem is where a very little bit of legal advice can go a long way, and there are no meaningful legal referrals. So there's really no place to refer them for assistance. And just a couple of quick things or a quick paragraph could really go a long way to getting something resolved. Those are those kind of create problems if there's nothing else out there to say, well, go talk to so-and-so, if there is no so-and-so there, and you know that there's no so-and-so to send them to.
Can you give us a specific example?
Well, I do conservatorships, and really there's really nobody who's doing, other than the agency that I work for, which is the Dozen Branch, that does that. And if there's, there may be on an objection, you want to do an objection, you really need to focus on what the key issues are on the objections, and you really just need to do a couple of key paragraphs in there, and it will take you 5 minutes to kind of write those up, but there's nobody else out there to prepare those paragraphs for them, especially if they've got very poor English skills or no English skills whatsoever.
My sense is that may even be an ADA sort of issue that gives you some coverage for drafting it for them. So long as it's their issue, and your job is being the scribe for someone who is inarticulate or illiterate, that is okay.
But that's scribing.
That's scribing.
Right, okay. As long as I'm scribing, and I'm
Yeah.
sure that I'm scribing.
Yeah. And some people, just to protect themselves in the situation, add a note at the bottom of the pleading that says, this pleading was prepared by Elmer Fudd in the self-help center or the conservatorship program, putting into the document the information provided by Mr. Presley on this date. Dana?
And I think a lot of times when people understand what the court needs to know, it really helps them to give you the precise information you need to act as scrivener. So in guardianship, for example, if you tell them that the court has to make orders in the best interest of the minor, you need to give the facts to the court to tell the court why the minor needs to be with you and not with the law, or whatever it is. When they understand what the court needs to look at, then they can give you the facts to put in, and you don't have this rambling long narrative.
Everybody here, Tina? Yeah.
How about outline declarations that really give the law, but then have the space so they're going to address that issue in their declaration, make it easier for the court, both the litigant and the court, to sort of follow what these people are trying to say. Creating some declarations for interest, for, background, maybe just as background. You could have some lines if the person wants. And they can check off it, they can use it, or they don't. It's sort of an expansion on, like, in family law, the application for the OSC. But, so it's got the things identified, but with some lines where they can, to guide them as they prepare their own declaration. Do you see any problem?
We were just in a session in which Harry and Diane Trunk from LA were explaining and displaying a computer program, a document assembly program that's been developed for LA by Harry Jacobs that does exactly that in a computerized process, so that the dialogue with the litigant lays out all of the grounds for the issue of the restraining order. Was there physical violence? Was there a threat of physical violence? Diane, what are the rest of the check boxes?
Well, threat was there, was there a threat to kill, there's issues that could come up. It also has, it prompts on the declaration, I am asking for these custody orders, the custody orders set forth in the DB 105 because, and then the volunteer interviews the living and puts that information is, I am asking for debt payment, I'm asking for payment of my rent in this amount because, So it's a computerized version of exactly what you're talking about.
And so when you get to the declaration part, displays that you checked those grounds. And then, in this case, it is, there's always a volunteer assisting with the process, but they can look at, that is the outline, and then the issue is what facts do you have to support your statement that there was physical violence, that there was a threat of physical violence, there was a threat of death.
And in my mind, as long as you have these declarations that really, like in family law, could be used by either side.
Sure.
You know, it's just a guide.
Yeah.
And they can choose to use it or not, that there would not be a problem with that, provided it's again neutral. You just, and they have their own facts that they're putting.
Right. Tina developed some forms. I remember a UD answer form that she had years and years ago that laid out all of the recognized defenses to a UD action in California. And it just, these are the bases for defending against an eviction. And it was up to the litigant to choose, to determine whether one of those applied, and if so, to articulate the facts that would support it. But there was nothing, it was a classic example to me of asking the question, what information does the litigant need to decide what to do? And it was in textbook sort of form. These are the defenses. Yeah, I'm sure Ventura is still using that form.
Can I comment on that form a little further?
Yes, Brenda.
Tia did a great job, we still use that form, but sometimes it depends on the bench officer doing UD, whether or not they like that form. Because what happens is, when it gets time for trial, the SLL has no idea how to prove that defense.
Yeah.
So that's the other side of that we have to do. And some of the commissioners are very strict. If you say it's uninhabitable, they expect you're gonna bring a mold expert. I mean, if people don't know that, they're gonna do that.
Wasn't there a workshop on helping people prepare for hearings and trials?
Yes.
Not insoluble, but another issue we have to figure out how to do effectively. But my view would be that just because a judge is frustrated that people are raising issues is not a basis to stop alerting them to the existence of those issues, but rather calls on us to do more to equip them to deal with the issue in that courtroom. Yes, sir?
What about, we're finding that we have a lot of cases that need a basic motion, procedural motion, like consolidating a TV case with an ongoing divorce case, something that the court would want done. But quite frankly, something that procedurally, for a lawyer, you got a boilerplate form in the office, you print it out and you send it in and it's done. But for a litigant, this is beyond, this is true legalese. This isn't talking about what I want for my kids, this is true legalese. You know, how do you feel, what's the, on just creating a boilerplate motion for that, a boilerplate motion for consolidation or something like that, where we have, you know, it's truly procedural.
You're explicitly authorized to do that, to develop a local form.
But we wouldn't be developing a local form, it would be using the AOC form, using the, you know, the FL 301 and having information on it saying this, and then the litigant would fill in the basics.
How many people have that kind of form right now? There are a couple of examples already, so no problem. Tina?
Yeah, I think that what Brenda had said highlights why there needs to be, you have the forms so that people don't waive their defenses and get their issues, but what I knew at the time when people were trying to defend unlawful detainers, they really do need a lawyer, because there's a lawyer on the other side frequently in those cases. And so that's the kind of thing where those lawyer for day programs are bundled, getting representation in on those, for the courtroom part of it. Because I think the workshops are all great to walk people through, but a lot of times when they get in courtroom, they freeze up. You can train them all you want, you have great, LA developed wonderful, workshop, tools for tenants in UD cases, but a lot of times they just, they get too nervous in court to adequately be able to present their case, or they may confuse what evidence they need to bring or forget to bring, and things like that.
Two comments. First, when self-help programs started, our whole focus was enabling people to get into the courthouse. And as time has gone on, we realized that it's every bit as important to help them get through the courthouse and out the other end. Just getting them into the courthouse isn't enough. And then I remind you of that little study that was done in Van Nuys of a legal aid program to assist in UD cases, where the lawyers quickly concluded that the best thing they could do for their clients was to point out to them that they're going to lose, and there's no way they can avoid losing. So their most effective strategy is to try to extend the date for move out and get the landlord to agree to waive the back rent and not seek any arrearages. So in part of, I think, the kind of information we need to give is to somehow convey the fullness of the law, that you don't pay your rent, but in most circumstances you're out. And the fact that you have it today is no defense. There are limits to what even lawyers can do, even the very best lawyers. Let me just raise a couple that I think we've talked about, the DD declarations, and I do think that outlined approach is a very appropriate one. Complicated property issues, with issues of separating out community and separate property, and tracing, is that the term that's used? The property from separate through the community, is it still, has it become community? Family businesses, multiple residences. If you approach this from the teaching metaphor, it is possible that you could provide enough information for the litigants in a complicated property case to analyze it, prepare the appropriate declarations and disclosures, and present it. But the guidelines specifically say you don't have the time, and it is not an appropriate use of your time to try to educate them, basically give them a couple of weeks of law school for the purpose of this one case. And by the way, if they have all that property, they have another option available to them. Yeah.
It is appropriate to suggest that. They have a lot of property and complicated property issues. And I'm just asking, and you can see them kind of going down the road where they're going to give up interesting community property.
You know, this,
I mean, how far do you go to say, you probably should private attorney to help with this?
and listen to the word you used.
Probably should. That was-
Should. You said should. And I have never been in a court where a judge raised any objection to court staff using should for this purpose. That it seems perfectly consistent with court policy to advocate for the use of a lawyer. And I didn't realize that, but when I heard what you said, I realized that that is a very standard practice in courts to say, you really need a lawyer in this case. And that is, nobody would ever say that's crossing the line. Yeah.
Well, I think we work in the same counties, and I think that it's one thing coming from a bench officer to say you should get a lawyer. There's a completely different standard versus if the CEO of the court has a disgruntled litigant who was said you might want to consult a lawyer. These are complex property issues. So I think it's all in the framing of how you provide that information, because I really don't think that in our role we ought to be saying the LD words should.
Yeah.
You should. I always frame it as you might want to. These are very complex, and it seems like you might not understand all of the case law and all of the statutes that might apply here.
A lawyer could explain it to you.
I think we're comfortable going a little further than that. I think in our centers, it's a very frequent thing for an attorney one of our self-help attorneys to say to somebody, your case has enough issues of complexity that we would really urge you. Here's the county bar referral service. We would really urge you. We wish there were more unbundled services available in our county. There's only one area that does that, but we will push them as hard as we can to get them to get an attorney. And in a circumstance where somebody with pretty complex property issues and what appears to be an ability to perhaps spend some of those assets to hire somebody, insists that they want to do it themselves, our staff will tell them that, we won't turn you away from a workshop, but we are not going to allow you to dominate the workshop time with your more complex issues. You're going to be, you could actually say, there are, 14 other people here today who have basic cases that we're going to go through so that everybody gets through, and you're welcome to participate, but we're not going to focus in on how to handle your complex issues. We really urge you to go see an attorney to do that.
The other one that I know comes up often is, and it would be particularly the wife who would come in and say, I just want to get rid of the bastard. I just want to get away from him, and I'm willing to walk away with nothing. I just want to get out of this. What do you do?
Educate them. But it's still their choice.
It's still their choice.
Absolutely.
But, and you can always frame this, if you just think it through. Explain community property, the principle of community property, the purpose of community property, why it is the law of California and other enlightened states like New Mexico. And then any pension or retirement account accrued during the course of the marriage is community property, and the other spouse has a right to half of the value. You can find out the value by going to an accountant who does that sort of valuation, and cost would be from such to such. Yes?
And I also think that in those situations, when sometimes they're emotionally upset, they're kind of angry and sad at the same time and feeling that they've been victimized, and to say that, they do have, that we found that people like you who have a long marriage, feel better about the process that they've gone and gotten some legal advice. So if you choose to give up something, you're understanding, so you're not victimizing yourself. And then we're in whatever way we can. And they that sort of makes them think, yeah, I could at least do that, and find that out, so I'm not doing it to myself. And I don't think that's legal advice. I think it's, again, telling them there's resources available.
Understanding that if they want to drive in the ditch,
They have a right to.
they have a right to drive in the ditch.
I think just explaining what you can't do to them, for them can really help. I'd say, people find that getting this kind of information, getting advice around this is helpful. We are not set up to do this. We can't do this. We're barred by doing it. And there are other resources out there that you may want to consult before you finish up with us, if you want to go forward with us today, fine.
I think that's very useful point. Very, very pertinent. Because while you have the signs up and you say, I'm not your lawyer, we don't have a lawyer-client relationship, there's no confidentiality, I can talk to the other side, saying it the way you said it brings it home again later in the discussion. Remember what I said, I am not your lawyer. I cannot be your lawyer because I'm part of the court. The court can't take sides. A lawyer can sit with you and tell you what is in your best interest. I can't do that. And here is an example where a lawyer could go through this and analyze for you what would be the best way to proceed to maximize what you would get out of it. In fact, yes?
I know for us, our difficult situation is people that know they have a pension and retirement account and don't want to disclose it anywhere. They'll check the box saying no community property, and they're telling us that there's a pension, they've worked for the government agency for the past 20 years doing that. And that's always the hard part for us to figure out how to coax them into putting down that pension plan in some way. But I'm not sure if anyone else has run across this situation.
Yeah, how do you deal with that?
Explain what happens with undisclosed assets later, and how it's avoidable judgment.
I've done that and they still refuse, but I guess that's all I can do.
Yes?
Used a lot of case. It terrifies people.
Yeah.
Use what?
I like a
Used
lot
a lot
of
of
case.
case. I mean, just say, you could lose it all, not half, it all. And then they usually, it scares people enough in our lectures. I spend a good deal of time explaining what happened. And so I say, you can put it down on the form, not put it down on the form. I can't make you do it. But if you don't put it down on the form, you don't put it on your petition, then you're going to have this issue hanging over your head. All somebody needs to do is a couple of years afterwards, when they figure it out, come back when you think you've got everything and you lose it all.
Super. Anything else? Yes, sir.
I might have misunderstood earlier in the presentation about helping people that already have an attorney.
Yeah.
My understanding is that once we find out they have an attorney, the only thing we can help them with is the substitution of attorney or, responding, trying to get that attorney out.
Right. But you can inquire. Do you still have the attorney?
Right.
And is the attorney assisting you? Did you have the attorney only for a limited purpose? Or is this attorney handling your case? Now, if this attorney is still handling your case, then I can't assist you.
On that issue, if you're lucky enough to have attorneys that do limited scope representation, then you need to make sure you're distinguishing between the piece. For example, we have a nonprofit law firm in Los Angeles that does a lot of limited scope representation that has worked out a relationship with our resource center where they send the pieces of the case that are easy for self-help for the person to do at our center, and then they're coming back and forth for the other pieces. If you have, in some counties, you may be lucky enough to have a good resource of private attorneys that do that, you need to be careful to make sure that you're not going into the areas that they have hired somebody to represent their own limited scope, but that you're helping them with the other pieces.
but the problem is that, you know, some of these smaller counties like where we live, they've never heard of a notice of limited scope, and then they just, or they're being lazy and they're sending their client out to the self-help center for some, and if there's no notice of limited scope on file, you know, our position is you go get one, or you get a sub-attorney, otherwise, you know, you're out. So it's a difficult situation, because the litigant's like, well, he told me that you can help me with blah, blah, but there is no limited scope. We're like, okay, hands off, go get that taken care of, either the sub-attorney or limited scope, then come back.
Molly?
Limited scope representation helps us do our job, so it's to your benefit, outreach to your legal community and educate them about this in any way you can, because the more they know about it, the better off you'll be. The easier your job will be, because if they will take that one sticky issue and litigate it, and you don't have to worry about it, you can just talk to the parties on the other side, that just makes your job that much easier. So do anything you can to educate them. Go to their bar luncheons, put an article in their newsletter, call them one-on-one if you know them, whatever it takes, but it's gonna help you in the long run.
In Maricopa, they have gone this far to encourage unbundled representation, that they allow attorneys who are providing limited scope representation to advertise in the courthouse. They have a loose leaf binder, and any attorney who is providing limited scope can put a page in there. It has to conform to a standard format of area of practice, length of practice, fees, where you live, so how close are you to this attorney. And when people ask, where can I find an attorney, you say there's a book of attorneys over there that provide limited scope representation. Now, I don't know whether that would be allowed in California. I don't know. I've never seen it anywhere in California.
We actually do that. I used to have the book, just general, but now we have distinct lists of attorneys who will do limited scope in different areas. So if somebody comes in and they mention they have pension, we say, well, we have a list of attorneys who handle pension issues.
I now know of 8 county, Sacramento, that doesn't do it in Placer. Okay.
And Orange.
And Orange. Okay.
When we're talking about attorneys, what are the other centers doing when someone comes in and says, well, I have a lawyer, but he or she, I can't contact this person. There's a long sob story about the reason that they can't get their lawyer to do what they want to do. And so they want to file regardless. We have the file by demand procedure where you just go up and file it anyway, even though you're not attorney of record. But I feel really awkward giving that information out to a litigant at the front desk, because that seems to me to be a little bit of a backdoor procedure for that.
Look in the guidelines and see how that it's in the ethical guidelines at the back of the guidelines. Somebody just read that and see if it is that you cannot serve someone who has a lawyer. That's my memory of the wording.
Assistance, provide assistance on any issue.
Oh, that's right, I quoted it, didn't I? That it is provide assistance on an issue on which the person is represented. Farida?
Look at cases where the attorney hasn't represented the person for 10 years, they just did the solo attorney, or the attorney has disbarred or has passed away, hasn't moved out of the area. So if the attorney's still local, but just hasn't been in the case for years, we just have a little bit of substitution of attorney. But if the attorney has passed away or has been disbarred or has moved out of the area and is relocated, we still go forward with helping them.
Even if they're still licensed California attorney, they just happen to be living, they happen to have a Vegas address now, you can still help them.
You do not?
We
Diane?
If you try to contact them, it's the issue of actively representing a litigant. That, I'm looking at that going,
Yeah.
what in the world does that mean? That could mean a lot of different things. Well, you haven't heard from your attorney in over 2 years. Is that active representation?
We actually debated that, you and I were on the committee, we actually debated this language before the guidelines came in. We were working on similar guidelines for our county, and our little committee from Los Angeles actually urged Bonnie and Deborah to include that language in here because we were seeing a lot of people who had an attorney that had basically dumped them ages ago, and no matter how many times they might try, they weren't getting through to the attorney, whatever the relationship had been. There was not an active, productive attorney-client relationship going on, and that even getting a substitution of attorney, no matter what kind of information you might give them about how the attorney is obligated under the state bar rules to cooperate in providing the file and all that, the reality is that it wasn't going to happen. And so we asked for this language in the guidelines as kind of a loophole to help you, to have your common sense be able to tell you when the person was really being mistreated by their attorney, and you might also give them the information about contacting the Bar Association, but that there was a way to help somebody with something that they really weren't actively being represented.
I think we've got very useful legislative history now, Diane. That was the purpose of that word, was to give you the wiggle room to assist in a case where there is a lawyer, but the lawyer is not actively representing. I am sorry that we have reached the witching hour. We have. Thank you very, very much. Christine, do you want to make an announcement about evaluation?
Oh, yeah, make sure that you fill out the evaluation by the end of the conference, so make sure that you don't forget to evaluate this class. Thank you. At the end, there should be a box at the end of the day where you can just drop it off. But if you are leaving early or whatever, just drop it off at the registration desk. Thank you. Thank you. Even if they owe you money, the attorney can't just sell them nothing and then try. So, there's certain things that we have to do as attorneys, we just can't kick them to the curb.
Do you remember, but it was when you just started?
Well, yes.
Well, you can answer these questions, let me talk to you one. Remember that? You were like, yeah, the one that had but she was calling in behalf of the dog.
It doesn't. No. What I would suggest you do is to say to Judge White, this is what I want to hand out to the people who come. And I actually want them to sign it and hand it clean.
What did it say, no eating?
This seminar. And not to pay for addressing specific factual situations in the case.
I'll run out and see if I can find Albert.
Okay.
And
So, present you.
That's great, or did I?
much of that, but
Or water.
they haven't had that either.
Okay.
Can you believe that?
Yeah, you have to find one of the,
So, say, the presenter is not an active member.
skinniest table I've ever seen.
Oh, okay. Then you don't put that, but you say the attendance at this seminar does not create any attorney-client relationship. Not, the person is not giving legal advice, but merely generalized information. No confidentiality. And we will include.
So have you been here all day or just?
No, about 10, 9:30.
I didn't realize that.
And
Heard he was here.
tell her that we talked to the.
Oh, really?
I didn't meet him until this morning.
Well, that
It's
was a
been-
bit good.
It's been quite a big guess.
She's crazy. You learn a lot?
Yeah, some. This morning, I said before. Not necessarily what they were talking about. Like, for example, this morning, Carol Bridges, something on reforms, and I wanted to really hear the reaction.
Did anybody say anything? What did they say?
Well, you know, there was a little bit of getting into, well, why don't you do this? The truth. A little just but overall, it seemed they were okay. And then he took the time to have this explanation of the whole process. I thought that was helpful, actually.
Yeah.
I thank you.
Oh,
Yeah, the way to it.
Even though to us it was like, but,
No need to react that much.
yeah, no,
I think he protected himself and explained the process.
we want to borrow this chair.
Well,
That's all.
Oh, you really nice.